Good morning, this is the Kelso Report for February 15th, and I'm your host, Clark Kelso. Well, we have cases today involving the First Amendment, government contracts, and a couple of cases involving family law issues. We begin with the Ninth Circuit in an interesting First Amendment case. What is the similarity between a civil court trial and a horse roundup managed by the Bureau of Land Management? Sounds like a bad joke, but that was the fundamental question before the Ninth Circuit in Lee v. Salazar, where the Ninth Circuit panel held the district court should use the same analytic framework used to decide whether the press and public have access to a criminal or civil trial in analyzing the question of whether a photojournalist should be given access to view a horse roundup managed by the Bureau of Land Management. According to the majority, the district court should analyze the claim of access to the horse roundup using the well-established qualified right of access balancing test set forth in Press Enterprise v. Superior Court, 1986 case where the Supreme Court articulated a balancing test to assess access to criminal trial court proceedings. The language in Press Enterprise was broader than just access to courts, however, and it suggested that the balancing test could apply to other access to government activities. Well, lower courts, of course, run with that suggestion, and now the balancing test will be used to determine whether there's a constitutional right to view government-managed horse roundups. Next, we have a case involving the interpretation of a government contract, the specialized area of law. Here, at the end of a 20-year lease program relating to 300 units of family housing located on an Air Force base, the United States and the owner of the units were unable to agree upon a purchase price, so the United States could just buy the units. They also could not agree on the amount of rent payable for an additional year of the lease. The United States sent notice of a one-year renewal under the original contract and then filed a protective action for condemnation eminent domain of a 5-month leasehold in the houses. The district court ruled that the renewal notice was effective, but it also ruled that it had no jurisdiction to set the rent for that year. In United States versus 300 units of rentable housing, the Ninth Circuit affirmed the district court's judgment, agreeing that the lease had been renewed, that the renewal essentially had mooted the government's condemnation action, that there was no need for the district court to set the rent for the renewal, and that only the Court of Federal Claims would have jurisdiction to consider a breach of contract action where the landlord could complain that the rent payments made by the government were too low. Sounds like a total win for the government. Now we have two family law cases, both of them, of course, tragic circumstances involving children who are going to be taken away from their parents. In the first, a minor child was removed from his mother's custody when she was arrested on a federal warrant, and the child was then placed in his father's custody with reunification services for the mother. But while the mother was still in prison, the court terminated the dependency jurisdiction, awarding custody to the father. Only a month later, though, the dependency was reactivated because of allegations that the child was physically abused by the father. The court then authorized reunification services for the father, but when he failed those services, the services were terminated, and the court turned to a permanent plan of adoption. The mother filed a motion to resume reunification services as to her, but that motion was denied and the court terminated all parental rights. The mother appealed, alleging that her constitutional rights were violated when the court did not consider placing the child in her custody at the disposition hearing after the father's failed reunification. The 4th District affirmed in Riverside County versus AA. Since the mother had failed to raise this objection below, she was still incarcerated at the time of the hearing and would therefore not have been eligible for custody in any event. the risks which had caused the court to remove the child from the mother's custody previously had also not been alleviated. And the court affirmed then the termination of parental rights. The second case, not much better. At a Section 366.26 hearing under the Welfare and Institutions Code, the court may select one of three alternative permanency plans for a dependent child: adoption, guardianship, or long-term foster care. Adoption is the strong preference if the child is adoptable. A finding of adoptability requires clear and convincing evidence of the likelihood that adoption will be realized within a reasonable time. If the court finds the child is likely to be adopted within a reasonable time, then the juvenile court is required to terminate parental rights unless the parent can show that termination would be detrimental to the child. In this particular case, the assessment report by the agency, although not as complete as it might have been, was sufficient evidence for the court to make the finding of adoptability, and it then terminated parental rights since the parents were nowhere near satisfying their burden of establishing a detriment to the child. That's it for today's Kelso Report. Have a great day in the law.